Welcome back to another episode of Law and Artist. My name is Mark Monlux, and whenever I have legal issues, I call up my good friend Daniel Abraham.
I'm Daniel Abraham, former illustrator, currently attorney, and over on the West Coast, no, Mark's on the West Coast, I'm on the East Coast. Between the two of us, we cover the nation.
Please read the following disclaimer. Daniel, today we're going to be talking about termination clauses. I like to come at it from the angle of a contractor, and when I show my client the contract, I show them the kill fee. It basically says I get 50%, maybe more if the work continues. For example, if the client finds out that the project's been canceled higher up, gives me a phone call, and no work has been done, I get 50% on the agreed amount. Had work been done on it, past the 50% mark, I would determine what that was and be compensated. But when I get a contract from a client, that's not the same.
No, it's absolutely not the same. I applaud, Mark, I applaud your looking at the payment for what work you've done. But the important thing to remember is that if you get a contract from your client, you have got to look at the termination clause. You've got to make sure that the termination clause says clearly what, when, how the actual relationship is terminated. You've got to be able to terminate the relationship when it becomes untenable, and you've got to have some sort of actual definite date in which to do so.
Another thing is in case they go into bankruptcy or receivership.
Bankruptcy or receivership is one excellent example, because the last thing in the world you want to do is get into bankruptcy court. You want to make sure that a termination clause ensures that if the client goes into receivership, if the client goes into bankruptcy, you get your work back because you don't want your work trapped in the bankruptcy court. The next thing is you have to be able to tell the client, to be able to make sure that the client is not going to be able to use your work for an indefinite amount of time after the termination. I had a series of clients a few years ago where they were working for limited edition print companies. These companies had on page 2 that the artist keeps his copyrights. Well, that's lovely. But on the termination clause on page 4, they said that as long as we continue to pay you the pittance of a royalty that we pay you, we get to keep printing the work and selling the work and distributing the work. That meant that the termination clause was not really a termination clause.
Speaking of terminating, that's pretty much it this week for Law and Artist. I want to thank everybody for watching, and thank you for answering my question, Daniel.
It is always a pleasure, Mark. It's always a pleasure to talk.